Do boo do boo do boo do boo do boo boo do boo do boo do boo do. All right, putting on the Ritz. It's simple 4/5, right? Syncopated timing, but we're putting on the Ritz today because what the heck? If you're old and balding in your mom's basement, you might as well be making bad puns at the same time. Um, we've got for you number two in our masterpiece, and I have to kvetch with you all. I was kind of shocked that we didn't get better reception on the last one read by Debbie. Maybe it was because it was read, I don't know. But you're not going to get a bunch of commentary from me here. We're just going to read this straight through. But I am excited about it. We did, I would say, some 6 weeks ago, we finally pulled the trigger, as it were, as a law firm to do what needed to be done for both the good of, I'd say, the state, the bureaucracy itself, and of course, our clients. Some of these things, sometimes when they're optional, here it's easier to put your head down and not do them. But we decided that we weren't going to do that. We're going to do something else. So you saw the first one, which was Stoller versus Department of Workforce Development, Amy PECHECEK there. And this one is slightly different, where this is Folaron versus Pamela McGilvery, and we'll get into it. So, bam. I think we can do this one. Hey, hey. This is what you call one of them summons. You are hereby notified. They get 45 days because it's the state of Wisconsin. Must be sent to the Eau Claire courthouse. Who's the judge here? Honorable Douglas Hoffer. All right. Boom, 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 boom. Here we go. Versus Teresa Folaron. Pamela McGilvery. All right, she's the deputy secretary. We'll just skip the parties later on. Then we got these are their work addresses, so let's not worry about that. Ramona Terra. She is the head of the Department of Workforce Development. She also signed the contract in question. McGilvery also signed the contract in question. Jennifer Wackerhauser is the custodian of public records for the Department of Workforce Development. Ashley Bannon is the custodian of public records for the Department of the Division of Hearings and Appeals. Why the custodian, you ask? Because one sues out on mandamus for public records. Mandamus lies against the office per capita, not against the body. I don't know the Latin for that one. I'm sorry there. Um, so, if you were, for example, to file a mandamus against a court, oh, you would be out of luck there, buddy, because mandamus goes against the officer. Likewise, if you were to file a root of supervision against the judge, you'd be out of luck. You'd need to file it against the court there or the inferior tribunal. That would be here the Department of Workforce Development or the Division of Hearings and Appeals. And then, of course, there's Brian Hayes. He's also signatory to the contract. What contract, you ask? Well, just hold on, if you please. He's the administrator to the Division of Hearings and Appeals. Remember, Department, Division, Bureau, Secretary, Administrator, Director. Bam. Section Chief, Worker. That is the order of rank of the state of Wisconsin. Complaint. Plaintiff Teresa Folaron by and through her attorneys, Cross Law Firm, SC, by Benjamin Hitchcock Cross alleges as follows. Introduction. Plaintiff has an employment discrimination complaint pending before defendant Wisconsin Department of Workforce Development's Equal Rights Division, stylized as Folaron versus Milwaukee Public Schools. The DWD is aware that the plaintiff intends to call Calvin Furman, who was formerly the deputy superintendent for MPS, as a witness in the ERD matter. On or about April of 2023, defendant DWD quietly hired Calvin Furman as a hearing examiner, or ALJ. We've talked about that quite some time, so we'll leave that alone. Whom the defendant, DWD, Administrator Ramona Natera knew was a potential witness in pending Wisconsin Fair Employment Act cases, including plaintiff, which the DWD, who enforces WFEA, Wisconsin Fair Employment Act, is mandated to hear. All right. The DWD assigned hearing examiner Peter Reinhardt to hear the plaintiff's claim. At a pre-hearing conference on June 7, 2023, the examiner divulged that he consulted with other examiners, including potentially Calvin Furman, about a motion filed by her respondent employer. That's Milwaukee Public Schools. The plaintiff began to demand public records of the communications between the examiner and his supervisor and colleagues. After plaintiff demanded and obtained public records, the plaintiff learned that the examiner heard her case under the direction and control of his supervisors. I would have struck that first line. Too bad I had no editorial control over this document, including Maria Selsource, who wrote drafts of the examiner's decision that the examiner presented to the plaintiff as his own. Okay. So we've got the supervisor of the hearing examiner, the bureau director, Maria Selsour, is writing drafts for the examiner, Peter Reinhardt, in Teresa Folaron's case. That's what the allegations are here. Instead of protecting the rights of the parties, the DWD then directed the examiner to participate in the hiring committee that eventually hired Furman to a full-time position. And on information and belief, directed the examiner to cancel the plaintiff's hearing less than 2 weeks before it was set to commence. Did I really put set to commence in there? When the plaintiff objected to the DWD administrator's involvement in her hearing, the DWD administrators directed their subordinate hearing examiners to recuse themselves from the plaintiff's fair employment case. Yeah, what I think is funny there, just as the comments that I'll leave is to myself, is it's amazing how many times one can go through a document, and each time one reads it, it's almost as if it's the first. Plaintiff then filed a motion asking the DWD to contract with another department to hold an unbiased hearing. The DWD took no action until the plaintiff complained to the governor and state senators. Then it contacted the Division of Hearings and Appeals, a nominally independent branch of the Department of Administration, empowered to hear some administrative hearings by statute. Not willing to risk that the DHA as an impartial neutral might reopen its decisions protecting Furman, DWD and the individual defendants negotiated an unconscionable contract imposing the admittedly biased hearing examiner's decision as the law of the case. Moving forward, under the terms of the contract, DHA's examiner may not disturb these prior, albeit tainted decisions, and does not receive compensation unless it enforces the same, including decisions protecting hearing examiner Calvin Furman, Furman's current employer, the defendant DWD, and Furman's former employer, Milwaukee Public Schools. Following the reassignment to the Division of Hearings and Appeals, the DWD administrators, including defendant Pamela McGilvery, interfered with the plaintiff's right to a fair, impartial hearing by conferring ex parte with the newly assigned examiner, Eric DeFort, through his supervisors, disparaging the plaintiff's counsel and otherwise prejudicing the examiner against the plaintiff. The plaintiff respectfully seeks judgment, finding that the defendants violated the plaintiff's constitutional rights to substantive due process, declaring that the DWD DHA contract, the contract is unenforceable due to being unconstitutional, unconscionable, and a violation of due process and or illusory, and enjoining the DWD and DHA for proceeding under the contract as written and requiring the defendants to provide her with records satisfying her outstanding public records request. Um, all right, here's the party section. We're gonna skip that, skip through that. Jurisdiction. This is interesting, as the defendants asserted herein are state officers. Employees are agents in official capacity. The court has the power to construe the DWD DHA contract under Wisconsin Stat 80604. Okay, sorry, two things there. Jurisdiction is appropriate in any county in the state of Wisconsin if the officers are state officers doing their duties. That's what's happening here, as we're alleging. Nobody's acting in their personal capacity by any stretch of the imagination. Now, the issue with that, I would say, is this. Why are we finally in Eau Claire County? And I think the simplest answer to that, I mean, there's plenty of other reasons why it may be Eau Claire, but I can tell you the reason it's not is it's not Madison, because the DWD is based in Madison. And it's not Milwaukee because Amy PECHECEK is formerly of the Milwaukee County. And you may say that there's no reason why they're connected or not connected, or who knows. But that's, I think, what the reasoning is with that. All right. Now, out of parties, jurisdiction, factual allegations. Now, that first part that we just read was just more or less the introduction, setting up what the case is. There's still now 9 through 31 pages more to go. You get what I'm saying? So, beyond that, the introductory statement really aren't necessarily facts. You're going to want everything in here to be, even it may be a repeat in some sense. That was our digest, our summation. What's that other word? Abstract. Bam. On May 11, 2022, the plaintiff filed Fair Employment Act sex discrimination and retaliation complaint against the Milwaukee Public Schools. On March 29th, the DWD certified the plaintiff's fair employment claims for hearing. Okay. Plaintiff has long alleged in argument and motions to the tribunal that former Milwaukee Public Schools Deputy Superintendent Calvin Furman, now hearing examiner for defendant DWD, was a witness to and potentially an actor in the discrimination that plaintiff endured during Furman's tenure as MPS Deputy Superintendent. In about April of 2023, the DWD hired Calvin Furman as a limited term employee, LTE, tasking him with overseeing WFEA cases despite his conflicted involvement as a witness in discrimination cases pending against Milwaukee Public Schools and the ERD. Prior to DWD's hiring Furman, at least one other former MPS employee, Deborah Keither, accused Furman's of employment discrimination as a decision maker. That complainant, Deborah Keither, published via YouTube the deposition that she took of Furman in her Wisconsin Fair Employment Act case. On information and belief, DWD administrators involved in hiring Furman were aware of the allegations, the published deposition, and the possibility that he would be called as a witness in a WFEA hearing, and hired him anyway. Furman complained to his DWD supervisor about Keither posting his deposition video to YouTube. A statute, WIS Stat Section 22750, prohibits ex parte communications relative to the merits of administrative hearings to and from the assigned hearing examiner and to and from any other official or employee of the agency who is involved in the decision-making process, and requires that hearing examiners disclose to the interested parties, that is, the complainant and the respondent in a given case, all ex parte communications exchanged between the hearing examiner and an official of the agency or any other public employee. The purpose of the statute is to ensure fair administrative hearings guaranteed by the constitutional and impartial hearing examiners guaranteed by WISTAT Section 22746 sub 6, mandating hearing examiners retain independence and conduct fair and impartial hearings free of outside influence especially from administrative agencies and their administrators. Okay, that's redundant, but we'll leave aside our self-criticism for later. On information and belief, DWD administrators and hearing examiners regularly deliberate on the merits of WFEA cases, meet and confer about parties and their attorneys, and provide each other advice about without disclosing these secret communications to the affected parties and their attorneys. All the DWD hearing examiners are lawyers and presumptively exercise independent quasi-judicial discretion and decision making, although they are not members of the judicial branch of government and are not overseen by the Wisconsin Judicial Commission. We've covered that, I think, frequently here. The 9 powers of the ALJs, I think, is the video on that one. The DWD is not an adversary or a formal party in any equal rights hearing before it. Hearing examiners do not represent the DWD in proceedings, but are rather neutral, bound only, I would say, are instead neutral, bound only by the facts before them, the motions of the parties, and the applicable law. I do see how it could be they are somewhat neutral, or rather, there could have more than one meaning. They are instead neutral. Throughout the plaintiff's WFEA hearing, Maria Selsor, the direct supervisor of all the DWD hearing examiners, including Furman and Reinhardt, and the direct report of defendant Atera, participated in plaintiff's proceeding. Oh! Do we have a something? I don't know. Ding 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 ding. I need a cowbell. That was a good one. All right. I'm hard pressed to state with a straight face one way or the other if that was clear or wasn't clear. If I recall that putting that in there or not. On December of 2023, Furman sued Keither and her attorney, undersigned counsel here as well, for defamation based in part on public comments about DWD's hiring of Furman. On information and belief, hearing examiner Peter Reinhardt consulted with Seltzer, and she edited and directed Reinhardt's pre-hearing decisions. Seltzer edited the following decisions in favor of Furman. August 2nd, 2023, on MPS's motion for protective order. January 16th, 2024, order on respondent's second motion for protective order. 23rd of January, granting Milwaukee Public Schools motion in limine, which limited the plaintiff's ability to discuss Furman at hearing. All right. The plaintiff repeatedly asked for the ex parte communications between Reinhardt and Seltzer regarding her case under Wisconsin Public Records Law. Defendant DWD v. Wackerhauser refused to produce them, claiming that it was refusing to disclose these communications as deliberations, attorney work product, attorney-client privilege information, and records relating to the Equal Rights Division processes. On its response is to plaintiff's public records request, DWD explicitly stated that it possesses public records of the DWD examiners discussing fact-finding, but refuses to produce them, asserting knowledge of the strategies and techniques used by the department to assign, manage, and decide cases that would put the fairness of the fact-finding process in jeopardy. And I think we've talked about that elsewhere here, but that one is a new interesting defense that they've put in that I don't think we've mentioned this fact-finding, but the fact that they would say put the fairness of the fact-finding process in jeopardy. I guess the question anybody might have on that is, how could there be public records that would demonstrate the techniques used by the department to assign, manage, and decide cases? Just the more I think about that, what would a public record, what would a public record look like that would describe how a administrative law judge should decide cases? It doesn't. I'm struggling with that one, but that's okay. Plaintiff also repeatedly asked for the same ex parte communications between Reinhardt and Celsoer regarding her case under Wistat 22750. Reinhardt, under the direction and control of Celsoer and DWD's administrator, defendant Ramona Otero, refused to produce the communications. DWD officials are biased against the plaintiff because of her attempts to depose its employee, hearing examiner Calvin Furman, who is plaintiff's former administrator at Milwaukee Public Schools, as a witness / actor in her discrimination case. Defendant DWD's official harbor animosity against the plaintiff for attempts to depose its current employee, examiner Calvin Furman, previously a high-ranking official and plaintiff's former employer, MPS, who she intends to call as a witness in her case. DWD's employment of Furman constitutes an actual or perceived bias or conflict against plaintiff because Furman is an adverse witness in the plaintiff's case that his colleague, examiner Reinhardt, oversaw. From working with Furman, Reinhardt developed a preconceived opinion that Furman is honest, truthful, and credible. I guess how do we put that? Open paren, and more credible than the plaintiff to the extent plaintiff's testimony may differ from his, close paren, and a propensity to protect Furman from uncomfortable and interrogation and exposure. Oh, there's some good words in there. In July of 2023, during a motion hearing, Reinhardt divulged that he consulted with his colleagues about how to respond to a motion made by Milwaukee Public Schools. Plaintiff objected to the failure to produce the ex parte communications to the parties and the appearance of bias arising from ex parte communications with Furman. When Reinhardt refused to state if he consulted with Furman, formerly employed by MPS, about MPS's motion, plaintiff asked Reinhardt to recuse himself. Over plaintiff's objections, Reinhardt made a priori evidentiary decisions that Furman's testimony was irrelevant. Reinhardt's decision relied on inapplicable federal law, but ignored clear mandates from the Labor and Industry Review Commission, which oversees equal rights examiners' administrative decisions. These mandates prohibit examiners from excluding evidence prior to a hearing any evidence. Plaintiff again raised this is what we mean by a priori, before the fact here. So it's that you haven't heard the evidence, but you're deciding about the evidence will be before you have any idea what it is. So therefore, you're excluding something as being irrelevant without knowing what anybody's actually going to say. Boy, have we seen that before. That's actually what started, I would say, this whole thing off. Plaintiff again raised this issue of appearance of bias and actual bias owing to the examiner's Reinhardt's connections to Furman. After learning that the attorney defending MPS and her WIFA claims was simultaneously defending Furman against a federal lawsuit brought by Keither at the direction of Celsoer, Reinhardt did not recuse himself. Be a little bit more clear here. But that's so Christopher Reardon is representing Milwaukee Public Schools at this point. Christopher Reardon is also representing at that point Milwaukee Public Schools and Calvin Furman against or in defense of Deborah Keither, who's claimed that Calvin Furman violated her civil rights, among other things, in her case that we read out here. So that is what happened. At the direction, so still, the judge didn't recuse himself after learning that not only was he found this guy truthful and honest, but also the attorney for the other side was also representing him. Do you think that's a conflict? On April 11, 2024, on information and belief, with knowledge that Reinhardt was actively overseeing a case in which Furman was a witness, Seltzer directed Reinhardt to participate in the hiring panel to promote Calvin Furman from an LTE to a full-time hearing examiner. That same day, Seltzer began drafting a recusal decision for Reinhardt. Seltzer specifically drafted the language about Calvin Furman. For example, an early draft read, and this is what Reinhardt wrote himself. In the event Furman is called as a witness in this case, ALJ Reinhardt would be potentially be personally biased in believing his testimony and viewing his testimony as credible. Accordingly, the ALJ Reinhardt believes disqualification is appropriate. And here's what Maria Seltzer wrote for him instead. We've got that video where we go through this in greater detail. Here, the complainant has stated an intention to call ALJ Furman as a witness in her case. And see, maybe her putting this in here wasn't the best idea. I don't know. The undersigned ALJ interacts regularly with the ALJ Furman in the course of his duties and views him as trustworthy and honest colleague. The ALJ believes that he would be inclined to personal bias and that he would find ALJ's Furman's testimony to be credible and give it great weight. Likewise, even if this ALJ did not find himself to be personally biased in favor of Calvin Furman, the appearance of bias would be too great to overcome. Given the working relationship and the undersigned ALJ's views of ALJ Furman's character and honesty. Huh. No DWD employee informed the parties at the plaintiff's WFEA hearing that Seltzer was participating in decision-making as plaintiff's case, or that Seltzer and Reinhardt were working together to hire Calvin Furman as a full-time employee just days before Reinhardt was expected to preside over plaintiff's hearing, in which Furman would appear as a witness and provide testimony adverse to plaintiffs. On April 22nd, 2024, less than 2 weeks before the hearing, Reinhardt canceled the hearing and recused himself, citing the potential for bias or the appearance of bias in deciding whether Calvin Furman should be allowed to testify, and if so, evaluating the credibility of Calvin Furman's hearing testimony and the weight to give his testimony. Reinhardt recused himself at Seltzer's direction. On April 22nd, 2024, plaintiff made public records requests to the DWD for all your correspondence with Calvin Furman and Maria Seltzer from the beginning of the year. On May 9th, 2024, the DWD partially responded to the April 29th request, producing records that documented the following. Reinhardt, Furman, and other hearing examiners meeting as described by Reinhardt. Hearing examiners discussing active cases before them. DWD officials drafting decisions for hearing examiners, including the plaintiff's case, and emails between Seltzer and Reinhardt discussing Reinhardt's appearance, the candidates, and the duties of the hiring committee that hired Furman. In desperation, on July 26, 2024, the plaintiff filed a motion to assign an alternate hearing examiner. By August of 2024, under the direction and control of Seltzer, all available DWD hearing examiners recused themselves, using identical or similar language drafted by Seltzer. The DWDs and its officials intentionally, unreasonably, and prejudicially delayed the plaintiff's WFEA hearing. B, in handing off the hearing to the Division of Hearings and Appeals, DWD's officials continue to prejudice the plaintiff by immunizing prior decisions tainted by admitted bias as the law of the case. Because there are no extrajudicial means to force the DWD to hold an impartial hearing, on September 8th, 2024, the plaintiff wrote a personal message to the Wisconsin governor, DWD officials, and various public officials, including state senators who sit on the committees that supervise the DWD. On September 16, 2024, DWD began talks with the DHA for contested hearing services on the plaintiff's hearing for the first time. On October 1st, the DWD Deputy Secretary Pamela McGilvery, ERD Administrator Natera, and DOA Administrator Hayes negotiated the contract for the contested case services to DWD. On October 1st, DWD Administrator Hayes informed McGilvery that his deputy examiner, Eric DeFort, would hear the plaintiff's WFEA claims. On October 2nd, the parties executed the contract. On October 15th, Maria Seltzer stepped from behind the curtain and took jurisdiction over the plaintiff's fair employment hearing from the DWD examiners and notified the parties of the DWD's decision to contract her case to the DHA because our internal hearing examiner ALJs have conflicts of interest under DWD 218.16 and Folaron v. MPS. For weeks, DWD and DOA officials had been secretly negotiating a contract. While the DWD DHA contract appears on its face to provide for contested case services, it materially omits that DWD sought outside hearing services due to bias of hearing examiner Reinhardt and other hearing examiners in favor of a particular witness in the case, Calvin Furman, and thus in order to ensure a fair hearing for the parties. Leaving out this material fact, the parties baked into the contract those decisions the hearing examiner Reinhardt reached when he was presumptively under the influence of said bias, and thus which are tainted by the same conflict and bias by binding the DHA to the DWD's law of the case. The DWD and DHA agreed that the DHA would ratify and adopt all decisions made by the recused hearing examiner, all but one of which he issued after he started working alongside his colleague Furman in April of 2023. After DWD secured those terms, the DHA determined what fee to charge the DWD. The DHA is charging DWD $135 per hour as the actual cost to conduct its hearings. That is more than the actual cost of the DHA. On information and belief, the normal rate of a hearing examiner is approximately $50 per hour. All right, we are going to leave it there. We'll do a little bit of exit music here. We'll get into part B. But there we go. This contract, I think, is going to form the whole basis of the lever here to that's going to give the plaintiff here, Ms. Folaron, a lot more rights than she might ordinarily have had, and I think that is all for the good, and we'll explain it more. I look forward to meeting with you soon. Take care. Stick with us. We'll keep you informed.